This is the Breakfast Club with Nick and Jackie on Rodney's More FM. Very pleased to have our resident lawyer, Jack, in the studio. It's Richard Worker. We've also got Jess in the studio as well. But from the legal team, legalteam.co.nz. You can go see them in Silverdale or go onto their website, legalteam.co.nz. But Jack, people can ask any questions they want, can't they?
Absolutely. You can send those questions into us and we will put them to Richard and to Jess as well. And we've got one in at the moment, Richard. I think this one's probably going for you. What happens if I pass away without a will in New Zealand?
It's a really good question, and it is one that we have sort of referred to or mentioned at an earlier stage because young kids now, and I'm just saying young kids, I mean kids who are working, we'd say, look, I haven't got anything, I don't own anything, and so, we don't need a will.
Yeah.
But the reality is, and it's a bit of a bombshell when I sort of do mention this, is that a lot of young, I'll call them kids, but young people, they've actually got KiwiSaver. And KiwiSaver mounts up very, very quickly. And
Yes.
And if one dies with more than $15,000 in an estate, then if one hasn't got a will, you have to apply for what's called letters of administration. It's a lot more complicated than applying for probate, and the estate is then administered under the Administration Act, and that means that the money, your assets, your estate doesn't necessarily go to where you want it to go. The Administration Act has systems where it says that if you have a spouse, then your spouse is entitled to the chattels, spouse or wife, husband, whatever, but is entitled to the chattels. They're also entitled to, if there are no children, they're entitled. The spouse gets everything. If there are children, then the spouse gets the chattels and what's called a prescribed sum, which is about $160,000 at the moment, which often will eat up, a substantial part of it or more of the estate, and the children get nothing. But if there is more than $160,000 in there, then it's divided into two, and it's divided between the spouse, and so the residue of the estate is divided between the spouse and the kids. And if there are no kids, it all goes to the spouse. If there's no spouse, it goes to the kids. But it's not necessarily what people want. So by doing a will, and it's just so important, it allows you to actually dictate where you want your estate to go to. Wills aren't hugely expensive. They're sort of $400 or something like that to get a tailor-made one. You can go online and have a will made. I just mentioned that just be very, very careful with online wills. And they're a great way of getting a will done, but amongst solicitors, we sort of have the standing joke that people who do their own wills have a fool for a client, so to speak.
Yeah.
And often they end up leaving the same property to two different people, and they don't deal with the residue of the estate or whatever it is. So, and then that's as bad or worse than having a will, because then the will's contestable and so on. So it is worthwhile, talking to your solicitor, public trust or whatever to get a proper will done. But I just say, wills are so important. They allow you to state what you want in your will if you do pass, where you want your assets to go, whether it's to go, part to your spouse, part to the kids, part to parents, brothers, siblings, or whatever. Really important. And without a will, it's a lot more expensive to administer.
Yeah, that's a good point. And so, with the will, here's a little question for you though after this. So my cousin is going through something similar with his partner, and they did leave a will, and maybe this is a separate question altogether, but what they're finding difficulty is that they don't actually have things like passwords to accounts and things like that.
Yep.
Does a will, should you put those kind of things in a will?
In my view, no, because they're dynamic things that change.
Sure.
And I advocate this very strongly with my clients. write down your passwords, and that can be from Facebook, and crypto's the classic. Without crypto, a lot of money's been lost through crypto because there's no password. But just put it into a sealed envelope, leave it with your will. It doesn't have to form part of your will, but it's really letting your executors know those details so they can get in. It's a really good question, Nick. And to be honest, it's really important. And the advantage of it, just having it in a sealed envelope or something like that, is that you can just update those without having to redo the will. There's no cost in you updating those. So very good point.
Okay, great. Thank you so much. That's great.